Hey guys, welcome to this video. My name is John Watts. What I want us to talk about is why it's so critical to understand both of these concepts of do I owe the debt and does the debt buyer, Midland, Portfolio, LVNV, whoever it is, do they actually own the debt that they are suing me on? So we have to understand owing the debt and then owning the debt. And this is, sometimes people will just focus on one or the other, and we really need to understand both of these concepts. So the two concepts are, do you actually owe the debt? And does the company that's suing you, this supposed debt buyer, do they own the debt? Now, let me tell you this so you understand kind of the importance of this. This is something that we first wrote about publicly in about 2007, so 13 years ago or more. And this is something that we have used. And just to give you an idea, we're typically hired by about 30 or 40 clients a month who have been sued by debt buyers. So you can, and it's not always been that number, it goes up and down, but give you an idea of sort of the volume of cases. So this is not something that is just theoretical or, 8 years ago I had one case and this is what we did in court. No, this is what we have been doing for a very, very long time. The industry has changed and morphed and but these two principles are still the foundational principle. Do you owe the debt? And then does the debt buyer actually own the debt? So let's look at this. Let's start with owing the debt. So if you do not owe the debt, then really nothing else matters, okay? We don't particularly care if the debt collector can truly prove it owns the debt, because if you don't owe it, there's nothing there. So what are some examples? I've got a couple on screen here. Number one, you may not owe the debt because you paid it off, okay? I mean, they said, hey, you owe $10,000, pay us $10,000, you pay them $10,000. Or maybe they say pay us $2,000, you pay them $2,000. Whatever it is, you've paid it off. And now that debt, which doesn't exist anymore, is being sold. Well, it doesn't matter. Even if Portfolio or Midland or LVNV or Calvary, whoever, they go, well, we really bought the debt. It doesn't matter if I do not owe the debt. Maybe you're a victim of identity theft. So somebody stole your identity, took out this debt. Well, you're not responsible for that, assuming you meet the requirements of true identity theft. And then maybe you do owe something, but it's in dispute how much. Well, can Midland or Portfolio or Calvary, can they prove how much you owe? I mean, can they start at zero and add up all the way to now you owe $1,714.63? Can they prove that? Okay, that's a big deal for them. So I'll say this, and I have this highlighted in kind of light blue down here. For most people that are sued by a debt buyer, Midland Funding, Midland Credit Management, Portfolio, Calvary, LVNV, Jefferson Capital, those type of companies, most people who are sued, they do owe the debt or at least some portion of it. Okay, but we always start there to say, do I actually owe this debt? Okay, so we've had cases where we pay off the debt and then the debt buyer and look, I don't pay debt buyers, but I'm saying my clients, before they come to me, they may have paid off a debt buyer. And then that debt buyer will sell that debt, even though there's nothing really there because it's zero, to somebody else. And that somebody else says, well, I can prove I own the debt. Well, so what? We don't owe it, so it doesn't matter, okay? But for most people, we say, yeah, I owe the debt or I owe a portion of it. And so now let's look at the idea of, does the debt buyer actually own it? So here's kind of the starting point. This is let's assume you owe the debt. Number two, did the original creditor sue you? Well, no, because we're talking about a debt buyer lawsuit. So Capital One did not sue me. Synchrony Bank, Chase, whoever the original creditors, they did not sue me. It's some stranger. Midland, Portfolio, Calvary, Jefferson Capital, they've sued me. So they say, hey, judge, we're a debt buyer. That means we buy debt. Well, congratulations. They go, well, no, it means we bought this debt. Well, here's the deal. In court, we don't deal in, Well, I'm just going to assume that Midland bought the debt. I'll just trust Portfolio, this debt collector. And you can read, go on CFPB complaint database, type in Portfolio, Midland, Jefferson Capital. You'll see whether or not they have any complaints about them. And you can decide whether you would just trust them and just say, well, they say they bought the debt, so I guess I don't need any evidence. I don't do that. I don't recommend anybody do that. We don't deal with assumptions in court. We deal with evidence. So as I have down here, can this debt buyer prove it actually bought your debt, and does it still own your debt? Because here's the deal. If it cannot prove that it bought the debt, or it cannot prove it still owns the debt, then does it matter that you owe it? No, it doesn't matter at all. Okay? So I owe on, let's say, a mortgage and a car loan, and I admit I owe. Does that mean I owe you for my mortgage? No. You can't say, well, John Watts owes somebody on his mortgage, so he has to pay me. No, I pay the person I owe it to. Okay? Now, if you say, well, I bought the mortgage of John Watts, great. Prove it. That's what you have to do. You have to prove that you own that debt. Okay? So here's some examples where we're talking about Midland Funding, Portfolio, any of these debt buyers. Does that debt buyer have the contract? And by the contract, I mean the purchase agreement. Okay? The purchase agreement's the actual contract where they would have bought not just one loan, they'll buy 10,000 loans. Okay? But there is a contract where they buy these debts. Now, what they want to do is give you the bill of sale. But in almost every situation, the bill of sale, and they'll usually put that with the lawsuit, it says this is an exhibit to the purchase agreement, or this is a part of the purchase agreement. Excuse me. And so remember the completeness doctrine. We have a video on that. And that typically is Rule of Evidence 106. It can vary by state, but in Alabama, that's what it is. And the completeness doctrine basically says if you're going to introduce a part of a document, the other side can make you introduce the whole of the document. So I've got this little booklet here, okay? And this is, I don't know, it's for vitamins or something. It's 20 pages. Well, if I say, well, look, I only want to introduce this one page. That's it. Nothing else. Well, if this was important, the other side could say, well, no, let's introduce the whole thing. So in personal injury cases, I want to just do this one little part of one page of a medical record. No, if I do that, all the medical records come in for the most part. So when they want to just put in a little taste of the contract, we say you got to put in the whole contract. So what's the big deal? Well, the purchase agreement usually, not always, but usually will say the documents and the information sold are being sold as is. Okay? It's like buying a car, used car, and they go, well, look, there's no warranty with this. You're buying it as is. The engine may fall out. Hey, I don't know. Same thing. These original creditors are selling something to the debt buyer. And think about it. The debt buyer is paying on average 5 cents on the dollar. So here's $100 million worth of debt. And this is supposedly valid debt. $100 million. Why would Capital One sell that for $5 million? $100 million for 5? Why would they do that? Well, because they have some questions about it. And typically in the purchase agreement, they're saying, look, we make no warranty that any of this information is accurate. So just understand that Portfolio, Midland, LVNV, whoever, we are not promising any of this information is accurate. We're selling this to you as is. Well, that's important because when these debt buyers come in with these documents and they say, Judge, this is the gospel truth. But the contract says, there's no reliance on this. There's no representation. Any of this stuff is accurate. Well, that has implications when we're looking at a hearsay analysis. Whether this evidence is hearsay and excluded, or is it hearsay that can be included in court? So that's a big reason why they don't want to put these purchase agreements in, because those purchase agreements typically will say no promise about any of this information being accurate. And then we want to know, who did Midland buy the claim from? See, did Midland buy it from the original creditor or from some other debt buyer? Because if it's some other debt buyer, then we've got to know for that debt buyer. Well, who did you buy it from? Did you buy it from another debt buyer? Or did you buy it from the original creditor? Or where, sort of in a chain of title here. Here's the original creditor. Here's Midland. Are they like this, or are there a bunch of steps in between? Well, that's important to know. Here's another example. So talking about really focusing on owing the debt. So I paid off my Capital One account. I had the proof. Portfolio claims to have bought it. Let's just give them the benefit of the doubt. Say they can prove they own it. So what? I don't owe the debt. So Portfolio can own everything in the world, including my non-existent debt. And it doesn't matter because they're going to lose. I don't owe the debt. Over here on the right side of the screen, so I'm a victim of identity theft with Synchrony Bank. I tell Synchrony Bank about this. They still sell it to Midland. Let's just, for the sake of argument, assume Midland can prove it owns the debt. Well, do I owe the debt? They own it, but do I owe it? Well, no. If it's truly identity theft, I don't owe that. And then, so I say in here, the focus in defending this will be to attack the idea that I owe the debt. Okay? If I don't owe the debt, I do not owe the debt, nothing else matters. Well, now let's kind of flip that. What about owning? So on the left-hand side, I admit I owe Capital One. And that's where Midland Credit, Midland Funding, Jefferson Capital, all these guys, they want to stop. They go, see, Judge, John Watts admits that he owes the debt. So we win. That's not the way it works. Now, I'll tell you, back in about 2006, 2007, we'd go into court representing people, and these debt buyers would be in there, and the judge would say, well, John, does your client owe Capital One or Synchrony Bank or Chase? I say, yeah, we owe the debt. And judge would say, well, then are you going to pay them any money? Nope. Well, why not? Because this company suing us does not own the debt. And I remember the first few times we did this, the collection lawyers kind of look at us and the judge would kind of look at us funny, like, what do you mean? We said, well, I don't have a credit card with Midland or LVNV or any of these other companies. They have to prove they own it. And there were sort of two reactions. One, the judge would go, well, yeah, that makes sense. They got to prove they own it. And the other reaction is the collection lawyer just being upset. Like, Judge, I mean, do you think we would sue when we don't own the debt? I mean, obviously we own it. We sued. The proof that we own it is that we sued. I'm like, that might be circular in a way. I'm not sure. It could be. Okay. And so that's half the battle. Just proving that I owe the debt. Then they have to prove that they own the debt. So let's say that Midland refuses to prove they own it, or maybe they're unable to. Frankly, it doesn't matter. Okay? When they're in court, if they choose not to, or they're incapable of proving that they own the debt, then does it matter that I owe the debt? No. And here's that example I used before. I may admit that I owe on my car, I owe on my house, I owe on student loans, I owe on this credit card, I owe whatever. Does that mean I owe you? No, unless you own the debt. So last example, Portfolio tells the court, since I admit I owe on a Synchrony Bank, that the case is over. And I say, I owe Synchrony Bank, but who in the world are you? Okay. And then they say they must own the debt because they bought it from Resurgent. Let's assume they can prove they bought the debt from Resurgent. Resurgent is sort of the parent company, if you will, of LVNV. There's a bunch of interrelated companies. There's Sherman Acquisitions, LVNV, Resurgent. They're all kind of this family of companies, and they play games with sort of how this stuff is structured. But let's just assume Portfolio can prove they really bought it from some other debt buyer. So what? Okay? If I sell you, I make up a fancy contract, and for, $2,000, I sell you the Golden Gate Bridge, and I give you deed to the Golden Gate Bridge. Does that mean you own the Golden Gate Bridge? No, it just means you got ripped off. Okay? You bought something that I had no right to sell you. So I don't care that Resurgent sold this to Portfolio. Big deal. Did Resurgent actually own it? And see, that's when these companies what we call subsequent debt collectors. So you have the original creditor, and then you have the debt buyer suing you. And let's say there's one in between. We say, well, let's focus on this one in between. Did they really buy it from the original creditor? And the debt buyer that sued you is like, Judge, I mean, we're not getting into that. They're not part of this. I mean, look, we bought it from that first debt buyer. So what? The first debt buyer has to prove that they own it to be able to sell it to you. So I hope that this is helpful. I know sort of, beating this into the ground, but I really, really want you to understand this concept of, do I owe the debt? If you don't owe the debt, then nothing else matters. But let's say you do owe the debt. Well, then does this debt buyer own the debt? Have they purchased it? Do they still have it? Can they prove that? Because if they cannot, then my position and what we have done over, 13, 14 years, however many cases that is argue to the court. If they do not own the debt, then they lose. And we've been very successful with that. So hope that that's helpful to you. And I appreciate you watching this video, and I'll catch you in tomorrow's video. Okay, have a good one. Bye-bye.